We're back in the wrongful death case today because this judge has filed so many orders. But do you remember what I said was going to happen at the end of the hearing on July 1st? You remember I said, well, Judge G said a few hearings ago, hey, if anyone's confused, you can just file a motion to clarify the record. Oh, they did. I said they were going to do it immediately. Immediately, they did it immediately. So we have 2 motions to clarify the record. And then we have Judge G responding to the motions to clarify the record, being like, that's not what I mean. I told you that's where we were going to be. And here we are. This is from July 1st. Emily, have we gone through this motion? No, I saw the title. It was buried with another set of motions though. But I saw the title and I was like, of course they did. From the emergency hearing comes the emergency motion to clarify the record from Karen Reed's side. Today, the court stated on the record that an attorney with an appearance in this case had, quote, violated either the letter or the spirit of the rule. That statement and those that followed were based on an incorrect premise. Oh, this isn't going to go well. Namely, the information that the court claimed had been disclosed by an attorney was already public as of June 6th, at the latest, more than 2 days before the filing or impoundment order at issue. Thus, the entire foundation upon which the court called today's hearing and admonished counsel was factually flawed. Shit. Well, that's not going to make the judge happy. They say on June 6th, the ex-user the court referred to today held a live stream on YouTube. Did the lawyers then get the information from the court? Because how do they know which ex-user the court was referring to? Because the court never really said. But the attorneys say on June 6th, the ex-user the court referred to today held a live stream on YouTube during which he stated that he had received the same information from a third party. Why aren't the lawyers saying what the information is, Emily? Well, if it is information that is sealed and impounded, they do kind of have to talk around the information. I'm hoping that the judge clarified to them what it was, but they have to talk around it. They say that that live stream was 2 days before the impounded filing the court believes was improperly shared. That YouTube clip is contained on a USB drive as Exhibit 1. So they put in part of a live stream as Exhibit 1. The following post that also predated the June 8th impounded filing also showed that the information in question was public prior to that filing. And then there's a post here that says, as to Proctor's deposition, which do you believe will most likely happens Monday? Poll ends before Monday's hearing. The poll options are judge grants the motion, denied and deposition, denied and no deposition are the options. I basically put a similar thing in the lounge saying, what do you think's going to happen? Is Proctor in some type of a treatment? I posted that on Friday. Then a ex-user said that Turtle Boy was live. They said TB, but Turtle Boy was live. Turtle Boy was live. The source, though not vetted, state that Proctor had been at McLean and transferred to a mental health facility in Florida. If that's true, did he have a nervous breakdown knowing Alan Jackson was deposing him? Are the Alberts concerned he is the weak link? I think they're more concerned about Higgins. Just thoughts. This had come to my attention before that hearing. This was not a secret. This was not unknown. This was being discussed. Was it true or not? I don't know. It was not unknown by anyone that is paying attention to this case. And then there's another post on X from June 7th, 26 from a different user from 7:24 p.m. in whatever time somebody grabbed this saying, I'm sorry, but if Proctor is in a hospital in Florida, did they not know this before the close of business on Friday? Valid question. Because Friday, they're like, we've just discovered there's this mystery information and our client can't be here Monday. I mean, valid question. But if this is being widely speculated about prior to anything being filed by the defense, I can understand why the lawyers are like, there doesn't have to be a leak. The court departed the bench immediately after making these statements without permitting any counsel to respond. Defendant Karen Reed counsel immediately asked to be heard to inform the court of these important facts that would correct the record, but the court refused to allow comment and refused to retake the bench when asked. Accurate. This is not all that Karen Reed's team had to say. Karen Reed's team filed an additional supplemental memorandum of law July 2nd. Defendant Karen Reed's supplemental memorandum of law in support of emergency motion to clarify the record after the court's emergency hearing on July 1st and after filing her emergency motion to clarify the record the same day, defendant Karen Reed became aware that the ex post that the court cited as the only evidence that its impoundment order had been violated was actually posted before the relevant June 8th filing by third party Michael Proctor. So the court must have given them exactly what ex post they were talking about at some point. The court stated at hearing that Proctor's counsel sent the relevant pleading and exhibits to the court and counsel at 2:22 p.m. on June 8th. It was right in that range, 2:22, 2:25. I trust their writing of it more than my memory of it, but the court said it on the record. The court said, and they're writing now, that the ex post in question was created, quote, exactly 30 minutes after the email to counsel of record and contained information, quote, similar to the information contained in Proctor's filing. As the court can see below, the ex post in question, which was provided to the court by Proctor's counsel, was created at 10:52 a.m. Eastern Time. The image provided by Proctor's counsel, that's some new information, had a 2:52 p.m. timestamp. I have so many I'll come back. I have so many thoughts. However, that is because it was apparently accessed by a user without an X account, which defaults the time zone to Coordinated Universal Time, UTC, 4 hours ahead of Eastern Time. When accessed by a user with an account set to Eastern Time, the post appears as follows. And this is a post from Turtle Boy. Michael Proctor decided to have a mental health crisis, and I'm reading this verbatim. Michael Proctor decided to have a mental health crisis after the whole world found out how racist he is. Sources tell us he checked himself into a mental health facility in Florida to try to avoid today's deposition. They filed a motion at the last minute on Friday to delay the depo. True. But the judge wanted proof. Also true. They submitted an affidavit that was impounded because it likely said Proctor was in a mental hospital. Karen Reed's lawyer made the mistake of saying the scheduling of the deposition was strategic, which the judge took issue with based on her comments on the Today Show. That's what the judge said in the first part of the morning hearing. That's accurate. He stayed at the depo for 24 hours and a 4:15 hearing will be held. There's some typos in that, but it is what it is. My guess, this is probably right at the end of that first part of the hearing. My guess is he's going to tell Proctor to jump on a plane and stop being such a pussy so Alan can depose him tomorrow. I mean, the judge didn't say stop being such a pussy, but the judge did say he needs to be deposed tomorrow. 10:52 a.m., June 8th, would be right about the end of that morning hearing. The message was actually posted more than 3 hours before Proctor's filing and not, quote, exactly 30 minutes after it. Therefore, the court's conclusion that there has been a violation of its impoundment order is based on a factually inaccurate premise. Oh, the judge is just going to get mad. The court's actions as a result of what it incorrectly determined was a violation of its order has primarily impacted Reed, who is the party who subpoenaed Proctor, began taking his deposition, scheduled a second day of testimony, and has spent significant resources compelling and taking his testimony. Because there is no evidence of any violation of the court's impoundment order, and because the court did not permit Reed's counsel to present any evidence on this point at the July 1st hearing, the court should now clarify that no violation took place and permit Reed to proceed with her scheduled day of deposition on July 14th. I think that's a fair request to clarify the record because, and before I crash out on the rest of it, because the judge stayed all discovery from Proctor, period, including further deposition. The court said that that was in effect until further order from the court. I guess we'll have to see if that's in any of the orders today. But right now, until we see an order that says otherwise, right now, discovery and deposition as to Proctor is still stayed. If the court had reached out to all the parties to ask for more information about this particular tweet, it seemed that all of this could have been clarified. It seems to me that the court had a very knee-jerk reaction to information that came to the court. Now, Emily, you've said the courts cannot do outside research. Right, they can't. But what the court can do is say, this information has come to me. Lawyers, I need more information. Requesting more information from the attorneys could have also been under seal, and seems that it would have maybe illuminated for the court, because the court, I'm sure, is unaware, and I genuinely think the court is unaware that this has been discussed online well prior to this. The fact that this was brought to the court's attention by Proctor's lawyers is some new information. But my bigger concern at this point is that no matter what level of fuckery is going on, we're still tick-tock on the discovery deadline, and everything as to Proctor is stayed. So ultimately, through whatever this is, Proctor's lawyers got exactly what they wanted. So the judge responded to Karen Reed's July 1st and July 2nd motions to clarify the record on July 6th. The judge did file a whole bunch of orders on July 3rd, but not this one. This got filed July 6th. Acknowledgement of various motions to clarify the record. The court has received Ms. Reed's emergency motion to clarify the record, submitted July 1st, 2026. Supplemental memorandum of law in support of emergency motion to clarify the record, submitted July 2nd, 2026. And motion to clarify the record, submitted June 12th, 2026, which was paper number 127. These motions have been docketed, but no action is required on these filings as they are not the proper use of a motion to clarify. You told them in multiple hearings that if they had questions, the proper procedure was to file a motion to clarify. And now you're telling them that these are not the proper motion to clarify. Such motion, a motion to clarify, should be a targeted request to the court to provide clarification of a previous judgment, order, or ruling that appears unclear. Maybe Reed's attorneys should have flipped this and said, Your Honor, we would like to clarify. Is the court's order to stay all discovery as to Michael Proctor still in effect? And flipped it so that that was what they led with, and then have gone, is this stay of discovery still in effect because? Can the court clarify if we may move forward? Maybe they just needed to lead with that, because it's at the end of the motion July 2nd. They asked the court to essentially to clarify if discovery as to Proctor is still stayed. It should not be used as an opportunity to respond to generic statements from the bench. You did stay all of Proctor's discovery, though. It should not be used as an opportunity to respond to generic statements from the bench, submit additional information, or to seek to get a party's position into the record. Oh, he big mad. Well, if nothing you said on July 1st mattered, why call everybody in for it? Footnote 4, paper number 127 acknowledges that its purpose is, quote, to address and respond to the court's statements. Any similar motions sought to be filed in the future will not be docketed. If counsel wishes to bring to the court's attention information discovered after counsel's June 26, 2026 letter to me, footnote 5, a motion for reconsideration in compliance with Superior Court Rule 9D would be the proper procedure, footnote 6. Footnote 5, such letter and the June 25th letter from counsel for the non-party are provisionally impounded pending any further hearing on the issues raised therein. So we don't know what the June 25th and 26th letters are because they're provisionally impounded. Footnote 6, Rule 9D provides that such motions shall be served So you told them to follow Rule 9D, and then you footnoted the language of Rule 9D. Rule 9D provides that such motions shall be served and processed consistent with Rules 9A and 9C. If a motion under Rule 9D is filed, Rule 9C conferral would necessarily include the non-party's counsel. You have to serve all the other counsel. You have to confer with Proctor's counsel about this before you bring it to me. Well, Your Honor, maybe you should have conferred with all the counsel before dragging them across the country and then not asking them any questions and just yelling at them. I recognize that conferral with the other parties in the case may not be warranted and accept such requirement at the option of Ms. Reed's counsel. Even though I do not consider the issue to be an emergency, I would, as always, accommodate counsel and schedule an expedited hearing on a mutually agreed upon date. Why have another hearing when you had all of the attorneys in one room? You could have sealed that hearing if need be. It is not unheard of that a court seals a hearing when the hearing is dealing with sealed information. The court goes on to say, with respect to the submissions of July 1st and July 2nd, the only relevant order was to preclude further attempts to take discovery from a non-party pending further orders of the court. Right. And which party does a stay on discovery as to Proctor impact when the discovery deadline is next month? The court invited counsel to come to an agreement to hold private information in confidence, which the court would consider entering as an order. If no such agreement is filed before 4:30 p.m. on July 9th, the court will issue further orders it deems appropriate. The court does not say here that the court is going to lift the discovery stay. The court said that if the parties do not come to an agreement on what a further discovery protective order is, that the court will enter that as they deem appropriate. The civil rules of procedure have provisions to protect personal identifying information. I don't think you need an additional order. But what the judge asked for on July 1st was, to me, this was my interpretation of it. What the judge asked for on July 1st was for the attorneys to agree that there would be stricter sanctions. And the court seemed to be trying to get the attorneys to agree to sidestep all the procedural protections to go after something like sanctions and contempt. And in the context of talking about stricter penalties for discovery violations of private information, the court talked about things like dismissal of the case, defaulting the case, which means the plaintiff's case goes away or the defendant loses, dismissal or default, sanctions, and contempt. Those were all penalties that the court considered. And I said then, and I feel more strongly about it now, that if you are the attorneys on this case on any side, do you feel confident enough in the court to go ahead and say, yeah, sure, let's get rid of the rest of the procedures to follow before you take an extreme remedy? No, I wouldn't do that at all. I wouldn't agree to that at all. I'd say, you know what? Let's keep what's in the rules. We don't need anything beyond what's in the rules because none of us have violated what's in the rules. I wouldn't trust the court at this point with that because the court has shown this more knee-jerk reaction of this came to my attention and I need to act on it. Everyone needs to pause in this case. And I'm not sure where the parties go from here. They're going to have to find a way to kind of de-escalate this case a little bit because I think it's going to get worse. Leonard, it's summer, and not only is it summer, but for me, it's summer in the South, and sometimes makeup can feel like way too much. But that's where today's sponsor, Jones Road Beauty, comes in because they have multitasking, skin benefiting, glowifying, my word, not theirs, makeup that is not only super easy to use, most of it comes in a stick form, and it just leaves your skin looking incredible. So when you're like, Emily, I'm loving the glow on camera. I know it's the Miracle Balm. It is a really easy way to just get a little bit of glow on your cheeks. Plus, in keeping with simplistic, easy to use, making your skin look amazing makeup, Jones Road has just launched a foundation stick, which means if you are looking for a little more coverage, but still a fresh skin makeup routine between your Miracle Balm and your foundation stick, completely handled. Plus, they have a gorgeous new location in Nashville. So if you're looking to check out Jones Road locally, you can always see if there's a location open near you. Leonard, what you're gonna love about Jones Road Beauty is that it's modern day makeup that's clean, strategic, and multifunctional for effortless routines, which we absolutely love. Plus, for a limited time, you get a free gift with your first purchase when you use code EDB at checkout. So just head to jonesroadbeauty.com and use code EDB at checkout for your free gift. And if they asked how you found out about them, let them know it was the Emily Show. Case briefs. And now let's get back into it. Decision and order on non-party Lieutenant Tully retired motion to quash subpoena and or for protective order. Let's take a look at what the court has to say. There's been a lot of litigation on this. We have not covered this litigation at this point. Upon review of the non-party's motion to quash and or for protective order, the opposition, the reply, the motion is allowed as to narrowing the document requests as set forth in paragraph 17 to 20 on page 13 of the motion, but denied as to quashing the subpoena. So the court is narrowing down the discovery requests, but is saying you still need to sit for your deposition and you still need to turn over discovery. I agree with counsel for the non-party that objections should have been filed and a Rule 9 conference should have been held. However, Emily, keep reading. The court is just like, tell me how you really feel, Your Honor. The court goes on to say, however, Ms. Reed's counsel continues with the practice of issuing facially overbroad subpoenas and not fulfilling the obligation under Rule 45 to take reasonable steps to avoid imposing undue burden or expense on the subject of the subpoena. Right. I'm surprised, truly, that they have not modified their subpoenas. The Reed subpoenas are too broad. They know that the court believes that they're too broad. They are, in fact, too broad. Why not narrow them down at this point? Faced with an apparent lack of communications by both sides and the choice between what may be considered two extremes, I choose the one I find the more reasonable. The court says there may be a reasonable inference in favor of the non-party's argument that the sequence of events shows the improper purpose of discovery. The court agrees, it sounds like, with Tully's lawyer that the Reed parties are fishing. That's what it sounds like, he thinks. However, the timing set forth in the motion and opposition is not determinative for either side. So why say it? The motion to dismiss in the federal case was filed on April 3rd, 2026, and Ms. Reed issued a subpoena in this case on May 19th, 2026 for June 11th. There was no objection, but rather a rescheduling to an agreed upon date of July 8th. They agreed, and then what happened? The court goes on to say, I repeat myself and say that attorneys' agreements need to mean something. Well, Your Honor, the only way to enforce them is by you enforcing them. With respect to the argument that the subpoena circumvents federal discovery limitations, the cases cited in the motion tells us what is undisputed. A judge has the power to manage discovery, but do not stand for the proposition that the state court proceedings should be stayed as a result of the federal proceeding. So Tully must have lost on that argument. Even if I were inclined to do so, the impending discovery deadline in this matter would dissipate any such inclination. So you're going to just whack at both sides and then limit the discovery anyway. That's the court saying to Tully's side, I'm disinclined to acquiesce to your request. And the first part is his whack at Reed's side saying, The subpoenas continue to be overbroad. Narrow them down. Y'all need to talk to each other. It needs to mean something. And now the court is saying the document discovery is limited to what is in the motion, but you need to go forward with the deposition, which is supposed to be, it seems, today. Let's talk about Reed's next motion that was filed on July 6th, shall we? Mass state police were subpoenaed ages ago. And then at the beginning of June, there was motion work with Reed's team saying that MSP had not yet complied. MSP and Reed's attorneys had agreed to reschedule the hearing on the motion to compel. So the dispute is over 473 emails. What is required when emails are withheld? You have to provide a log of what the email is and why it's being withheld. So you have to put in the objection. This is privileged. This is work product. This is redacted because there is sensitive information regarding police investigation. Whatever it is, you need to put in and identify each of the emails and why they are being withheld. You need a privilege log. Defendant Karen Reed's notice concerning MSP compliance with court's order. On June 26th, the court entered an order on defendant Karen Reed's motion to compel the MSP, which stated, quote, the MSP is to produce a privilege log as it should have a long time ago. Such privilege log is to be produced on or before 3 p.m. July 3rd, docket number 29. MSP has not produced any privilege log to this order as of 11 a.m. on July 6, 2026. Therefore, Reed requests the court to order MSP to produce the documents that were the subject of her original motion to compel, which MSP continues to withhold pursuant to the work product doctrine. Do you see what remedy they're asking for? Look at that. The remedy they're asking for is that because MSP failed to comply, they're asking the court not to make MSP turn over the privilege log. They're asking the court to make MSP turn over all the documents. Okay, Your Honor, they don't want to turn over the privilege log. They lose the ability to object. Make them give us all 473 emails then. I wonder if we'll see the court do it, because deadlines have to mean something. That would be an appropriate discovery sanction. You failed to turn over the log with objections, so now you just have to turn over all the documents. You've lost the opportunity to turn over a log. That would be an appropriate discovery sanction. Let's look at that order that we have not looked at yet. The MSP is to produce a privilege log as it should have done a long time ago, footnote 4. Such privilege log is to be produced on or before 3 p.m. July 3rd, 2026, footnote 5. Let's go look at the footnotes. Footnote 4. It is hard for me to get too worked up about the MSP's failure to produce a privilege log in this instance, given in another discovery dispute in this case, the plaintiffs claim Ms. Reed has not produced a privilege log in response to a request for production served in October 2025. Girl, be so for real. Okay, I withdraw my statement that the judge might make them turn over the documents. There's no way the judge is making them turn over the documents. Ms. Reed did not dispute the claim, but rather points to a Rule 9C conference not yet occurring to talk about the timing of when Ms. Reed will give the plaintiffs the privilege log. Your Honor, seriously? Such privilege log is to be produced on or before 3 p.m. July 3rd, 2026. And then the footnote to that says, I am hopeful that the process will reduce the number of emails that it may be necessary for the court to review in camera. Your Honor, are you looking for a reason to not have to review the emails and see if they need to be turned over? If the discovery is annoying to you, which literally is 90% of being in civil court is discovery, it's like 3% trial, 6% hearings, 90 whatever percent discovery. If the discovery is too annoying to you, get a discovery referee. I expect, Your Honor, then, if you're going to go tit for tat with all the lawyers, I expect to see it as to all the lawyers. What a bitch ass footnote. I don't have another word for it. That is a petty ass footnote. This is an order from the court. Order requesting information from defendant Karen Reed relative to opposition to motion to quash filed by non-party Tully. So we looked earlier at the court's order regarding Tully, and the court's order was the Reed subpoena is way overbroad. Agreed. The Reed subpoena is way overbroad. We're narrowing down the subpoena, but you got to go sit for your deposition. We're not quashing that. Go sit for your deposition. This is in that context. On or before noon, Monday, June 29th, defendant Reed is requested to provide the factual basis for the following statements in her opposition. Buoyed by the treatment that other subpoenaed witnesses are getting by resisting their depositions and, quote, the manner in which other subpoenaed parties have been handled in this case. So the judge is calling Karen Reed's team into the principal's office again to say, explain your snips. Why are you snipping at me? Emily, but we already read what the court ruled with regard to the Tully motion. Yes, we did. But there is tea that we have left in the pot. Defendant Karen Reed's opposition to motion to quash. Sentence fucking 1. Apparently, damn it, they came out of the gate with the fucking snark. Apparently, buoyed by the treatment that other subpoenaed witnesses are getting by resisting their depositions, subpoenaed witness Brian Tully now seeks to stand in the same line by filing a motion seeking to quash his subpoena. And like other subpoenaed non-parties, Jennifer and Matthew McCabe, Brian and Nicole Albert, Brian Higgins, Colin Albert, and Julie Albert, and there's a parentheses inside a parentheses, who just didn't show up for her deposition on June 16th, who all ignored Rule 45 requirement regarding valid objections to document requests, Tully now wants the court to credit his invalid objection and does not want to produce any documents either. Could they have said this more gently? Yes. Are they going to keep locking horns with the judge if they keep filing like this? Yes. Do they have a strategy for that? Maybe. But it's not going to get better. Tully argues that the document requests are too broad and unduly burdensome. But there was only one way that he can even raise the objection. He needed to preserve it under Rule 45 by making an objection within 10 days. He didn't do that, and it wasn't close. Moreover, his attorneys were involved from the very beginning, and they provide no reason in their brief, let alone good cause, for their failure. However, putting that aside for a moment, this is their writing, not mine. Tully's counsel didn't even attempt to communicate with Reed's counsel about narrowing prior to serving the motion. Nor did Tully's counsel conduct a Superior Court Rule 9C conference. Rather, it appears that Tully simply watched the manner in which, this is the court takes issue with this, watched the manner in which other subpoenaed parties have been handled in this case and made a calculated decision to ignore the agreement between counsel to go forward with the deposition on July 8th, ignore Rule 45 requirements, and hope that somehow the court will forgive it. And the court did. The court narrowed the scope of the subpoena. The court has an opportunity here to demonstrate that subpoenas actually have meaning. Attorneys' agreements to convene depositions on certain dates should be enforced, and rules of civil procedure actually have consequences. Okay, what did Tully reply? So instead of responding the next day, Tully's attorneys waited till June 24th to reply and then filed this June 25th. And then the court responded the next day, June 26th, and was like, explain what you mean. Why'd you say this about me? They say, on the question of timeliness, Lieutenant Tully does not dispute that his written objections were served after the 10-day period prescribed in Rule 45C. He addresses that issue directly below. That's the only thing I want to look at is the untimely issue, because untimely! What are we doing? They are saying that there is no 10-day deadline with regard to a stay on a deposition, and the court can invoke at any time, quote, for good cause shown under Rule 26C, a stay to protect a person from, quote, annoyance, embarrassment, oppression, or undue burden Reed's opposition, they say, does not identify any procedural bar to a Rule 26C motion brought at this stage because there is none. Whatever view this court takes of the document request objections, it retains full authority to stay the deposition itself, pending the federal court's imminent ruling on whether Reed may maintain any claim against Tully whatsoever. The court actually took the position kind of opposite of what Tully's arguing here and said, okay, I'll limit the document discovery, but you have to go sit for your depo, which is supposed to be today. So they're saying that Reed is trying to jump the line on federal discovery, and that's why she's trying to take his deposition in July, that it's not as necessary to the wrongful death case. But the wrongful death discovery deadline is August, 17th, 16th? So Tully says that they are willing to confer and they think that the court should stay the deposition until after the July 14th hearing. But what does that matter even? The court's unlikely to rule on the motion to dismiss at the July 14th hearing. So what does staying the deposition until after July 14th even achieve? Because federal courts can take months and months and months to rule on motions to dismiss. And the day after the grouping of Tully motion to quash motions had gotten filed, the court said to Reed's attorneys, hey, you need to explain to me in 3 days why you made these comments in your motion. What is your factual basis? And that's what we're turning to next. Defendant Karen Reed's response to court regarding opposition to motion to quash filed by non-party Brian Tully. In response to the court's request, docket 135, defendant Karen Reed provides clarification of the two statements contained in her argument against Tully's motion to quash, which are presented below, along with additional portions each to clarify Reed's meaning, and were not included in the request. Excuse me, Your Honor, context. Apparently, bold and underlined, because that's the part that the court used an ellipses for, apparently buoyed by the treatment that other subpoenaed witnesses are getting by resisting their depositions, subpoenaed witness Brian Tully now seeks to stand in the same line, all right, bandwagon, by filing a motion seeking to quash his deposition, emphasis added. Rather, it appears, bold and underline, that Tully simply watched the manner in which other subpoenaed parties have been handled in this case, emphasis added. These two arguments refer to the fact that multiple third parties Reed had subpoenaed have either ignored such subpoenas, and therefore the court's commands, or sought to evade them, which will likely leave her forced to conduct a dozen or more depositions during the final month of discovery in this case. Oh shit, there's 11 points. Let's go through the list. Point number 1. On May 20th, 2026, Colin Albert informed Reed that he would be indefinitely unavailable for deposition after June 2nd and continued to refuse to produce nearly all documents Reed sought. On May 20th, 2026, Tully, through his counsel, agreed to July 8th for Tully's deposition, parentheses, which was moved at his counsel's request. We acquiesced to his scheduling. On June 1st, 2026, Brian Albert served objections to producing documents well after the deadline to object had passed, and the next day claimed to be unavailable for multiple weeks that followed his subpoenaed date. On June 1st, 2026, Nicole Albert served objections to producing documents well after the deadline to object had passed, and the next day claimed to be unavailable for multiple weeks that followed her subpoenaed date. On June 1st, okay, I'm not going to read each one. Same for Jennifer McCabe. Point 6, same for Matt McCabe. Point 7, not same for Allie McCabe. So we're going to read point 7. Point 7, on June 1st, Allie McCabe served objections to producing documents well after the deadline to object had passed, and the next day stated that she was unavailable for her chosen deposition date. However, she later agreed to appear on such date with only 2 days' notice and then testified that, in fact, she never had concrete plans, i.e. reservations, traveling companions, etc., requiring her to be away on the date of her deposition. Your Honor, she said she was unavailable when in fact she wasn't unavailable. On June 5th, third-party witness Michael Proctor filed his emergency motion for protective order seeking to continue his deposition scheduled for the next business day, despite having been properly subpoenaed in April 2026. And then on June 8th, the court essentially let him not be deposed on June 8th because of the way that the court proceeded that day. On June 16th, this is point number 9, Julie Albert failed to appear for her properly subpoenaed and noticed deposition. Number 10, on June 18th, 2026, third-party witness Tully suddenly served his motion to quash after his counsel had previously accepted service of the subpoena on his behalf and requested that Reed reschedule it, which she did. Point number 11. At no point before June 18th, 2026 did Tully object to the subpoena's request for responsive documents. These events form the factual basis for the arguments referred to above. I think it's somewhat constrained, all things considered. But the court asked for more information, and here you have it. Massachusetts State Police emergency motion to extend the deadline to comply with the June 26, 2026 court order, unbeknownst to third-party MSP and its counsel. On June 26th, this court issued an order on defendant Karen Reed's motion to compel MSP. It was not until receipt and review of an email this morning from attorney Aaron Rosenberg, which included a notice concerning MSP's compliance with court order, that counsel learned of the June 26 order. They say that they did not receive the court's June 26 order that we went over today until Rose sent them all the other stuff. They say, attached is an affidavit from undersigned counsel outlining non-receipt of the court's June 26, 2026 order. Let's see what they say. Attached is an affidavit from undersigned counsel outlining non-receipt of the court's June 26, 2026 order or any orders from the court since MSP's involvement in the case. What, did they have your email wrong? Seems odd. Given that neither MSP nor its counsel received the June 26, 2026 order, MSP requests an extension of the July 3rd deadline to July 14th to comply with the order. MSP sought defendant Karen Reed's assent to this motion. Defendant Reed did not respond. Maybe they didn't get it. The attorney is affirming under penalty of perjury that they did not receive a copy of the order by either electronic or first-class mail on June 26 or any day thereafter. I learned of the order in an email this morning from attorney Rosenberg, which included a notice concerning MSP's police compliance with the court order that we went over earlier in stream. After receiving Rosenberg's email this morning, I checked my email inbox for receipt of the June 26th order. Inexplicably, I do not have an email from the Odyssey file system or any other source with a copy of the order. I have not received any orders in this case from the Odyssey file system since becoming associated with this case on or about June 10th. I have contacted the court and will also engage my IT provider to understand and immediately correct this error. Honestly, it could be as simple as the court entered this person's email address wrong. All right, the court might grant that. Look, clerical errors happen, and generally courts are a little bit more chill about it. Decision and order on defendant Karen Reed's motion to compel Alberts, McCabe's, Allie McCabe, Brian Higgins to attend deposition and produce documents pursuant to non-party subpoenas. In this motion, docketed June 29th, Ms. Reed seeks an order requiring non-parties each to individually provide 3 non-overlapping dates for deposition before July 17th and to provide responsive documents within 10 days. The filings reflect that non-party Allie McCabe was deposed on June 18th and non-party Brian Higgins' deposition is scheduled for July 9th. Oh, tomorrow. So it is not clear why the request for dates includes them. As to the dispute, as to the remaining non-parties, it's an awkward sentence. I am not sure what is more in conflict. Oh, God. What could be more in conflict? 1, the statement by Ms. Reed's counsel that he, quote, was and is willing to accommodate reasonable scheduling conflicts and concerns, with the failure to pick one of the many dates set forth in paragraph 8 of the affidavit of counsel for the non-parties, or 2, the failure of counsel for the non-parties, as referenced in Ms. Reed's reply, to describe to the court the concerns about specific requests with the knowledge of the staunch position of counsel for Ms. Reed that the non-parties waived their right to object. The positions of both counsel simply result in unnecessary motion practice. Reed's counsel is not picking dates of the dates set forth, and non-parties counsel are not describing at all the specific requests. They're just sticking their, feet in the mud and refusing to move. The court says it is ordered that on or before Thursday, July 9th at 3 p.m. tomorrow, Ms. Reed's counsel shall notify counsel for the non-parties of his choice of the July deposition dates offered for each of the non-parties. On or before Thursday, July 9th at 3 p.m., counsel for the non-parties shall notify Ms. Reed's counsel in writing of the concerns about specific requests, not general objections. You pick a date, you actually make an objection without vagueness. Get it together. Counsel shall then confer to try to come to an agreement on the requests that can be narrowed. Counsel should be able to narrow the request without the court stepping in. Go talk to each other. Previous orders and action of the court on similar motions may provide counsel with some guidance. Go look at what I've done, talk to each other, and figure it out. If counsel cannot come to an agreement as to the narrowing of the requests, they shall set forth their respective positions in a submission of not more than 1 page to be filed on or before 3 p.m. July 13th. Why so long on that? Why not make them do it on the 10th? I mean, the court did say if y'all can't agree, you need to file with the court. And now they have. And the court's like, why can't you agree? So we are now waiting for those filings that are supposed to be done by tomorrow. Tomorrow we have other cases to look at, but I will be keeping an eye on what is likely to be a very active docket. At the end of the day, we're going to end up in August going, see? All of the attorneys are in court saying, Your Honor, we didn't have time to get everything done. Sorry, we need more time. And the court's probably going to give it to them. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the LawNerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.